Hello there, my name is Stephen Payne. I've been dealing with school exclusions since 2003, a long time. Much has changed during that period. Today, I'm going to talk to you about the 2017 exclusions guidance. This is the guidance that is used by head teachers, by governors, and by independent review panel members when dealing with exclusions, both fixed term and permanent. First of all, I want to talk to you about the Timpson report. This was produced in May 2019 by Mr. Timpson, who was Minister for Schools for a period. Hello there, my name is Stephen Payne. I've been dealing with school exclusions since 2013. Today I'm going to talk you through the 2017 exclusions guidance. This guidance is used by head teachers, by governors and by independent review panel members when considering exclusions in schools. First of all, I want to talk to you about the Timpson report, which was published back in May 2019. Edward Timpson is a former education minister. He wrote this report due to the increase in numbers of children who were being excluded from schools. And he wished to, in particular, tackle the particular problem of off-rolling. That is where a child isn't excluded from a school, but effectively is. He thought that schools should be better equipped to intervene to ensure that children are not permanently excluded. He recommended that the statutory guidance be rewritten by the summer of 2020, but unfortunately, due to the current situation on COVID, that has not been possible. In his report, he said it was important that teachers should be supported to maintain a safe and orderly environment for everyone within the school community. Schools and their partners needed to put in place effective interventions to give pupils at risk of exclusion the best possible chance to succeed in life. He wanted greater clarity for school leaders about when and how it was appropriate for a child to be removed from their school, and make sure there was proficient oversight when a pupil moves around the education system. In particular, he was referring here to the problems of off-rolling. He wanted schools to have support and providers of alternative education to also have support, so that pupils that were excluded continued to receive a high quality of education. He said that there was a lack of uniformity amongst schools, and students could be excluded from one particular school, whereas at another school, by doing exactly the same thing, they would not be excluded. He thought that some of the school units were well used, but at other schools, they're not as effectively as used as others. Some schools used managed moves in the best of interests of the child, whereas others did not. They needed more guidance to stop the unsuccessful, uncoordinated moves, commonly known as the shunting game. Currently, schools are only required to arrange alternative provision for exclusions of more than 5 days. However, some pupils may be excluding multiple exclusions of 5 days or less, and that resulted in a significant loss of education. Many alternative provisions already offer outreach workers, others don't, and he thought that that needed to be highlighted too. He said it was good practice in this area and importance of the role that alternative provision can play in helping children that are at risk of exclusion. He was concerned about safeguarding as well. There's also going to be a consultation on the 45-day fixed term limit. And this was due to be looked at in that summer 2020 review, which of course did not take place. So that's the Timpson's review. So let's look at what we have at the moment in the 2017 guidance. Everything for exclusions for all state-funded schools are taken from section 51A of the 2002 Education Act. And that got updated in section 4 of the 2011 Act. And when we talk about state-funded schools, we're talking about all schools that are community schools, voluntary aided, foundation schools, trust schools, and academies and free schools. So it applies to all schools, the majority of the schools that are in England. It doesn't apply to sixth form colleges. They have an entirely separate procedure. And there is a statutory instrument which deals with regulations, which was published in 2012. So 2012 means that was published to take into account the differences that came in after the 2011 Act. But however, we still have to look at a number of aspects in the 2002 Act, and in particular, what does it mean to exclude? Well, exclude must be on the grounds of a disciplinary matter. A child cannot be excluded for anything other than disciplinary matters. Exclusions can be permanent or fixed term, but they mustn't be more than 45 days in any one school year. Head teachers, governing bodies and independent review panels must have due regard to the statutory guidance. And these are contained in regulations 2012 and 14, and there's a website of which you can download those regulations if you wish to read them. The Secretary of State issued a temporary guidance in October 2020, and here again there is a link to that particular set of guidance. That guidance in particular really only talked about time limits and the fact that appeals should be heard online. It's important that the word should is now recognised, whereas previously it was the word may. So governing bodies and independent review panels must take reasonable steps to meet deadlines. Parents are to be given 25 days to appeal to an independent review panel. In the 2017 guidance, it's only 15 school days. This has been extended during the COVID period to 25. If a meeting is face-to-face, they must consider protective issues. However, experience has shown that all such meetings at governors or at independent review level are now held online. But however, there may be a case whereby a deadline has been missed, and if that's the case, the hearing should be heard as soon as possible. Governing bodies and independent review panels must be satisfied that all participants have access to technology. So if a parent doesn't have, for instance, the school could offer an empty schoolroom with a computer. All participants must be able to put across their viewpoint and fulfill their function, and the meeting must be held fairly and transparently. And it's the responsibilities of the governors to make sure that these conditions are met both at the governor's stage and at the independent review stage. I would suggest that the chair asks some suitable questions if the parent is happy about this before the hearing starts. If someone can't attend, or the governing body or the panel need to consider the following: would they have attended if the meeting was face-to-face? So if the local authority don't turn up, for instance, would they have turned up in the first place anyway? That needs to be taken into account. The circumstances in which a face-to-face hearing could have taken place, so the governors do need to consider the health of either the governors themselves as the panel members or the independent review panel. They also must consider the needs of all participants and the latest guidance offered by the DfE on public health. One of the problems sometimes comes up is that parents say they would rather not hold the meeting virtually. This can be a fair point, and must be considered by the panel. It would also be fair for the panel or the governors to point out that if it's not heard virtually, then any decision is going to be delayed and could be delayed by quite some time. If it is expected that the parents agrees, so should all other participants. If the parents is happy for the hearing to go ahead on that basis, no governor or panel member should really be objecting. All legal responsibilities still remain. So for instance, the governors must provide a translator if requested, minor adjustments for those that are disabled, and also consider remote access for the excluded child. If the governors or the panel believe the hearing is not being conducted fairly or transparently, then they would have to need to consider reasonable adjustments. From my experience, I've had this on one occasion whereby I did actually stop a hearing because I felt that it was not being held fairly and transparently because of the system used for the hearing. And then the hearing was heard a week later and everything was fine. Need to ensure that everybody understands the proceedings and is able to communicate with each other. It would be fine for the meeting to adjourn if the meeting was not being heard fairly, and this is what happened on a previous occasion. What if the participant loses connection? Well, we could try things like using the telephone to connect into the video system, but if clearly the parents are being treated unfairly by this, then clearly there needs to be an adjournment and meet on another occasion. It's still the responsibility of the independent review panel to provide that SEN expert if it's been requested, and the law does not permit written appeals unless at the wish of the parent. The panel must provide clear instructions on how the meeting will proceed, and if a chat box is used, then how that's going to interact into the meeting. From my experience, I find that chat boxes don't work well for independent review meetings, although they can be quite useful for admissions. As I said, the governors are to give the appellant 25 days to lodge their appeal, but there's no change for the governors' meeting. All other timescales remain in force. So this is a guidance, it's not a code. Panels and governors must have due regard to the guidance and can move away from it if there is good reason. And at the moment, the good reason might be COVID, and therefore the timetable, and that's all taken into account on the temporary regulations. However, it needs to be borne in mind that this court case back in 2002, that appeal panels and schools too must keep in mind that guidance is no more than that. It's not direction and certainly not rules. So if you have good reason and it's recorded that you have that good reason, then you can move away from the guidance, but you must bear in mind that you could be criticised at a later stage. So teachers and head teachers have a statutory duty to discipline pupils whose behaviour is unacceptable, and that's encompassed in the Education Act 2006 in sections 90 and 91. So a teacher could, for instance, tell the child that they've got a detention. However, it is only the teacher, a head teacher, or the principal that is they're the only person that can actually exclude someone, and that's for fixed term or even permanent exclusion. Nobody else in the school can, that's quite clear. However, there is a grey area about, is it the executive head, is it the head of school? It should be in somebody's contract, if necessary, or in job descriptions. If in doubt, it has to be the head of paid services. So that would be the executive head. So please be careful on that. It's certainly not going to be the deputy head. If the head teacher is not there during the day for some reason, there's no reason why the head teacher could not be contacted by telephone. And a deputy head could make a decision to exclude a child on a fixed term basis, but would have to be referred back to the head teacher for their agreement at the first available opportunity. It would be very unwise for a deputy head teacher to permanently exclude somebody, it would be far better if they were put into an isolation unit until the head teacher returned. So that exclusion has to be for disciplinary matters. It could be for just part of the day, and that would include lunchtime. But those lunch times must be counted in that 45 days. So the most important thing and the most awkward thing of the 2017 exclusions guidance is in paragraph 3, whereby a head teacher cannot extend a fixed term exclusion or convert from a fixed term to a permanent exclusion immediately after the first period ends. Now, this can be very difficult because most head teachers would not like to make a decision all of a sudden. They would like to think about it, an investigation, and so therefore the normal practice used to be to give a 5-day fixed term exclusion and then decide what to do at the end. Unfortunately, that is not an option that is available. It is suggested that the term other sanctions may be considered. However, schools may wish to seek their own legal advice on this. A child can be excluded for behaviour outside the school, but it needs to again look at what's actually in the school's behaviour policy. Moving back to this problem of fixed term exclusions, the DfE actually say that what schools should do is exclude permanently, then do the investigation, and if during the investigation it's found that the permanent exclusion is not a suitable option, to then remove that option. Most head teachers find this a rather cumbersome way of dealing with things. Unfortunately, it is part of the nature of the beast, but it can be, according to paragraph 5, withdrawn by the head teacher any time, as long as it's not already been reviewed by the governing body. Any decision must be lawful, rational, reasonable, fair and proportionate, and must meet the wider legal duties under Human Rights and Equalities Act. Head teachers must consider the legal duty of care when sending a pupil home. So if a child is age 7, clearly you would not send a child home unaccompanied. Either the child's parents are rang to ask them to collect the child, or somebody from the school must take the child home. When considering all matters to do with exclusions, a head teacher must consider the civil standard of proof, the balance of probabilities. You're not looking at beyond all reasonable doubt, which is what the police use. Often at hearings, you will hear parents say, but my child was considered by the police to not have broken the law, and that's because, of course, they were dealing with beyond all reasonable doubt, whereas head teachers are only dealing with the balance of probabilities. Nevertheless, head teachers must not discriminate under the Equalities Act. There can be no harassment or victimization due to sex, race, disability, religion or belief, sexual orientation, pregnancy or gender reassignment. Basically, the personal characteristics cannot be broken. The head teacher could not, for instance, permanently exclude a child because of the fact of their race or their sexual orientation, or because they're pregnant, or any of the other protected characteristics. However, the school also has to consider the public sector equality duty. Head teachers must comply with statutory duties with regard to SEN matters and have regard to the SEN Code of Practice. The SEN Code of Practice is now some 80-odd pages long, and governors and independent review panels will often find that these are quoted at hearings. It would be unlawful to exclude on non-disciplinary grounds, for instance, a girl being pregnant. Cooling off periods remain unlawful, and that's regardless of whether there is an agreement from the parent or not. So a head teacher that says at 2 o'clock, I think you should go home for the afternoon and cool off, I've spoken to your parents and they're quite happy about this. That is unlawful. Maintained schools, so not academies, may direct a pupil off-site without parental permission. So for instance, a respite, or if they went on an anger management course, if it was a community school that was run by the local authority, the head teacher has the right to actually send the child onto that course as an alternative provision. However, with an academy, the head teacher would have to seek permission from the parents. Pupils from all schools can be transferred as part of a managed move, and this is now actively encouraged to ensure that there is a fresh start. Head teachers cannot use the threat of a permanent exclusion to influence parents to move their child. So when talking about options in the future, head teachers need to be careful to say that although I'm suggesting a managed move, and I think this will be good for them because it will give them a fresh start, they can't then go on to say, well, of course, if you don't accept that, then I'm going to permanently exclude. A number of head teachers have ways of dealing with this, alluding to it, but be very careful exactly the wordings that are used. So the decision, and this is an important factor, paragraph 16 is 2 limbs. The connector is the word and. So in all letters that go from head teachers to parents explaining why a child is permanently excluded, it must include both limbs, not just one. So it's in response to a serious or persistent breaches of the school's behaviour policy, and where allowing the pupil to remain in school would seriously harm the educational welfare of the pupil or others in the school. Let's look at the first paragraph. It says, in response to a serious or persistent breaches. So clearly from that, it could be one incident or it could be persistent breaches. It cannot be a serious and persistent. It's one or the other. That is very clear, and that is very important, that when head teachers write letters, they put exactly the reasons why the child has been permanently excluded, and it must fit into this category of either a serious or persistent breaches. But then go on to say, and whereby allowing the pupil to remain in the school would seriously harm the education or welfare of the pupil of others in the school. If it doesn't contain the second limb in the letter, then clearly there's no demonstration that that was taken into account. If it's not in the letter, then panels, whether it be governors or whether it be independent review panel members, would have to look at this quite clearly and wonder why and ask, did you consider it and how did you consider it and how can they demonstrate that they considered it? Decision to exclude a pupil should not be taken lightly, and where practical, the child needs to be listened to before they make a decision, but it must be the head's decision. So if the child has been arrested and taken away, clearly that's more difficult, but where possible, heads must take into account why the child did what they're alleged to have done. There's a little bit here on uniform. I'm not going to go into that in any detail, but there is some government guidance which was published in September 2013. Alternatives. Guidance no longer gives details about alternatives to permanent exclusion, but paragraph 16 does make it clear it can be for a one-off offence, so this a serious incident, or it could be a persistent breaches culminating in an incident, but be very careful about the wording on that. The guidance is very silent on alternatives, but it used to be in the old guidance, and certainly it was there from 2008 onwards. So again, governors and independent review panel members need to explore with the head teacher, why didn't you look at a managed move, restorative justice, fixed term exclusion, internal exclusion, or mediation? Head teachers need to take into account contributing factors. For instance, bereavement, mental health issues, or being bullied, SEN issues. In fact, what we're looking at here at the moment is everything from paragraph 17 to 25. This is the actions of what the head teacher should be doing once they're looking at the permanent exclusion, whether to exclude or not. And therefore the governors should be asking the question, did you look at this? Did you look at that? So we're going through this now. So need for early interventions to identify or address any underlying causes of disruptive behaviour. Should include an assessment whether an alternative provision is in place to support an SEN or disability issues. An assessment should consider other issues such as mental health or family problems. Again, it's looking at the overall picture of the family and whether that would have affected the child's behaviour, which led to the possible permanent exclusion. Head teachers need to consider if the exclusion is an effective sanction. So if there've been a multiple number of fixed term exclusions and you're approaching the 45-day limit and nothing seemed to be working, therefore, something it needs addressing here, something really is wrong. Look at other things as well. As well as in early intervention, head teachers need to consider what extra support for those that are at high risk. For instance, children with an EHCP, those with SEN issues, looked after children, Roma children, travellers, Caribbean boys, all those on free school meals. That's in paragraphs 21 and 22. Head teachers, where possible, need to avoid permanent exclusion any child that has an EHCP or is a looked after child. And schools need to actively engage with parents. And if it's a looked after child, the foster parents in supporting the behaviour of pupils with additional needs. So where there are concerns about behaviour or risk of permanent exclusion, a child with additional needs or the EHC plan or looked after children, the school needs to work in partnership. Need to consider whether the HCP is in place, whether it's suitable, and need to consider an early or interim review. And again, any governing panel or independent review panel should actually see a copy of the last review that was done for the child, whether that be early or interim or just either the annual review, and to see what targets were set, to see where the child was going. Again, I remind everybody about 29A(3) of the 2002 Act about the fact that you can't direct a child to alternative provision if the school is an academy. So what must the head teacher do after making that decision? They must notify the parents without any delay the reasons for the exclusion, the period, whether it be fixed term or whether it be a permanent exclusion. And if it is permanent, it needs to make it absolutely clear it's permanent. Parents and pupils have a right to make representations to the governing body, and these need to be in the letter of how these can be made and all sorts of other details. There's also some guidance in the guidance about emails and whether that can be used or not. Again, I'm not going to go into detail on this particular course. But they must make clear that the parents should ensure that the child is not in a public place for the first 5 days of the exclusion. And head teachers must notify parents on the day this applies without delay or by the end of the afternoon session, and cannot exclude beyond the school footprint. Heads must use their own judgment and act in accordance with their school behaviour policy. If alternative provision is being made, then details about that need to be again in the letter, or if it's not known at that stage and it is going to be forwarded to the parents at a slightly later stage, then details about that need to be in the letter and that needs to be followed up as well. So don't forget that head teachers cannot convert from the fixed term to the permanent exclusion. Parents are to be advised that they can contact other people advice such as Quorum or ACE. Both Quorum and ACE will only give generic advice, but there are other agencies that are available on the internet that parents can actually go to. The head teacher needs to consider where English is not the first language, would it be sensible to have the letter translated? Be very careful about such things. If the letter is translated, please do send a letter in English as well, because if anything comes back in law, it'll be the letter in English that the courts will take into account. We all know that you can translate from one language to another in 2 or 3 different ways. So what about if the police are involved? Well, if they are involved, their teacher either needs to act fast or will need to consider what evidence they have available based on what they had at the time. They must make sure their decision is fair and is there sufficient evidence available. Parents still have the right to appeal to the governors, and the governors cannot adjourn. So even though the police investigation is going on, the governors do need to discuss it. They can't just adjourn because there's a police investigation going on. Although that could have affected the independent review panel, in most cases it does not. So the independent review panel needs to consider, when considering a police matter, has the pupil been charged? What is the charge? Are there any relevant witnesses or documents available? Most often or not, when an independent review panel, certainly when the governors are meeting, it's not at that stage at all. You might have heard that a child has been arrested, but that's the only details that you would have. But where a panel does agree to adjourn, the clerk must monitor the progress through the courts, and the courts have decided that head teachers are not required to interview a pupil with a serious crime before deciding on a temporary exclusion, but to address that's very different when it comes to a permanent exclusion. So again, it's all about that interview that you have, the head teacher has with the pupil before the police are called, that the head teacher must take into account matters that are available to them at the time and then make a decision on that basis. So what about an offensive weapon? What is an offensive weapon? An offensive weapon can be anything. Take a school compass, which has a rather nasty, sharp edge to it, poke that in the eye of someone and that will do you some danger. It is not something that's going to be listed under the Offensive Weapons Act of 2006 or 2019. So anyone that suggests, oh, well, yes, it was a knife, but it was less than 3 inches long, so therefore it's not a weapon. Yes, that's not a weapon under the Offensive Weapons Act, but certainly in the case of a school, that would be considered an offensive weapon. I'm not going to go through the details about the pupil referral units or alternative provisions. There are some notes here for you to follow up in your own time. And again, reintegration back into school. Again, I'm not going to go into those details. So the role of the independent review panel is to review what the governors have done. So let's look at what the governor's role is very, very briefly. So the first thing to remember is that there is a slight difference between a maintained school and an academy. For the maintained school, 3 governors must do the review. If it's an academy, that number could be smaller. It depends on what the Articles of Association say or the general rules of the school and the behaviour policy. So it could be 2 people. But in the main, it's going to be 3 people. And they must meet within 15 school days of receiving notice of the exclusion, of any permanent exclusion or fixed term exclusion of 6 days or more, or where it would bring either up to 15 in a term or 45 in a year, or indeed if the child is going to miss an examination. Okay, so if it's less than 5 days, then parents can request up to 50 school days that they have a meeting with the governors to discuss why the child had a fixed term exclusion. But none of this will go through to the independent review panel. So where an examination could be missed, it is perfectly permissible for the parents to speak to one governor. Very unusual this, because normally governors make corporate decisions, but where it is to move because of missing a test, parents do have the right to actually make oral representation, and that's usually done by telephone. But bear in mind, there's no automatic right to take an examination or a test. So who is going to be at the hearing? So the parents are certainly going to be there, and they can bring any representative or friends they wish. The head teacher must be there. Local authority, if it's a maintained school, they should be there. If it's an academy, then it's up to the parents. They must be asked, do you want the local authority to attend? Some opt for them to attend, others don't. If they do attend, then it is up to the governors as to whether they are able to speak or not, although most governing bodies would allow the local authority to speak. All parties must have due regard to the guidance which is issued by the Secretary of State, and governors must not discuss the exclusion with any party outside a meeting. You'd be surprised of how in the past it was a sort of a gossip item at governors' meetings. Governors are to ask for any written evidence in advance of the meeting. So although the school will prepare a pack of information, the governors could actually say, well, no, actually, I'd like to see A, B, and C as well. And they certainly should see any policies that they think are relevant. And that will probably include at least the behaviour policy, in many cases, the SEN policy, and there could be an exclusion policy, but it could be any other policy at all. If the child was caught smoking or was taking drugs, then there might be a smoking and drug policy. Any policy that's deemed to be needed to be reviewed needs to be in the pack. Governors must consider what steps they need to take to ensure that everybody is able to speak at the hearing, particularly if it's a virtual hearing, and that takes into account their age and understanding. So clearly, if a child is 7 years old, the governors probably wouldn't expect that child to attend that hearing. But if the child was age 13 or even age 11, certainly they would expect the child to attend the hearing, and they should be given every opportunity to put their own views across. So what decisions can the governors make? And all of these are made on the balance of probabilities. They need to consider any representations made by the parent or the head teacher, and anything that the local authority has to say as well. If the child has left the school, then clearly you can't reinstate the child back into the school, but a note's put on their records. So here are the two things that the governors can do. They can decline to reinstate the pupil, and so therefore that's uphold the head teacher's decision, or direct reinstatement immediately or on a particular date. Certainly that particular date shouldn't be that far into the future. So they must consider if the child has already left the school, that a suitable note to be put onto their file if they decide that they were going to reinstate. The governors must consider all parties are going to participate in the meeting and ensure that whoever is clerk in the meeting produces clear minutes which must be available on request. Bear in mind it says on request, so unless the parents requested it, then it would not automatically be sent to the parents. There's no suggestion here that the parents would have to agree to what was actually said in those minutes either. All parties except for the clerk with the governors must leave. It states that the clerk may stay. Well, as the clerk is going to write some minutes of the deliberation and to help with the wording of the letter, it would be sensible for the clerk to stay. Governors need to consider whether the decision was lawful, reasonable, and procedurally fair, taking into account the head teacher's legislative duties, and any outcome must be included in the pupil's record. Where the governors do not reinstate or cannot reinstate, consideration be made to put a note on the pupil's record. Claims to the first tier SEN tribunal or county court can be made up to 6 months after the alleged discrimination has occurred. So what are the questions that governors should be asking at these hearings? And in fact, these are much the same questions that the independent review panel should be looking at as well. So going through them very briefly, how did the school show boundaries? Were the incidents impulsive? What's the difference between impulsive and premeditated? So a child who actually walks up the stairs, goes into a room, sits and thinks about an incident and then does something that's premeditated, Whereas the child that gets annoyed straight away and throws a book across the room, that's clearly impulsive. So did the school make reasonable adjustments? What policies were considered and did these include? So for instance, looking at things like the behaviour policy, SEM policy, inclusion, drugs, or any other reasonable policy. And were these legal, reasonable, procedurally fair in line with paragraph 166 of the statutory guidance, which refers to the school. So governors need to consider actions of the head, and the independent review panel need to consider the actions of the governors. But of course, they're also looking at the head as well. So what documents they need to see? They need to see, for instance, letters from the head, why they excluded, letters from the clerk inviting the parents to that hearing, papers relating to the exclusion of the incident, the behaviour record, witness statements, and any physical evidence. I'm going to cover about witness statements here, although there are notes about this further on in this course. Witness statements must be signed and dated. Now, there will be many reasons why schools will want to redact names and why they would want to redact, in particular, the names of the witnesses as well. As long as it says things like student A, student B, and there is a date, then that is fine. But all statements must be at least dated. It is important that the governors do not see a version of these any differently to the parent. So the parent should not be shown transcript, whereas the governors are shown the originals. They must see exactly the same. Interim review is important if it's an EHCP. Any relevant policies, parents' paperwork, the local authority's written statement to the PDC. If it's given in writing, it may be done verbally. Does the pupil have an EHCP? If so, have the governors and the interim and the independent review panel, they seen the annual assessment? Was there an interim review? If not, why not? Does the pupil know the difference between right and wrong? Does the pupil have BSED, behaviour, social and emotional development issues? And that in itself is not a disability, but it could be the case. Is the pupil disabled? If they're disabled, was it diagnosed by a clinical psychologist? Has he or she been excluded due to protective characteristic? You need to look at strategies. Were CAMS involved? If there's an EHCP, was it referred to the SEM panel? Were external agencies used? Some people would argue that all children who have particular needs need to be assessed by an external agency. Others would say not, because the school has the facilities and the ability to actually perform those tasks internally. So there might be good reasons. Were the alternatives considered? If not, why not? So things like the managed move, restorative justice and mediation. And then, of course, governors must consider the equalities legislation as well. So continuing into this direction of paragraphs 17 to 25, need to consider 22 and 23. Now these say, as well as having disproportionately high rates of exclusion, there are certain groups who are vulnerable with particular needs, and they need to be looked at, and that's the children with EHCPs and those that are looked after children. And also the governors need to look at how well did the school react with the family, and were the family involved on a very regular basis, and if the child is a looked after child, were the foster parents utilised as well. And so did the governors or the head teacher fail sufficiently to take into account paragraph 22, which is important when looking at avoiding permanent exclusion? Did the school proactively encourage parents in supporting a child that had an EHCP? Looking at also mitigation as well. So who made the decision? That's important. Was it the head teacher? And it's important that it has to be the head teacher. Have the parents seen exactly the same set of paperwork as the governors? That's important, very important that. Paragraph 11 Head teachers and the governing body must comply with their statutory duties on SEN matters. So again, the SEN code of practice, that needs to be considered as well. So again, there's some more notes here on further probing. I'm not going to go those details on this particular short version of a course. So parents receive the letter saying that the child has been permanently excluded. What's next? Unfortunately, here's where there is some problems, because Regulation 8 states that the parents must, I underline the word must, give their reasons for their appeal in writing, where unfortunately 76C of the guidance states should set out. So that contradicts the regulations. In law, the regulations take precedence, and so therefore the governors and the school and an independent review panel have the right to know what the grounds are at the time the appeal is lodged, and not just a few days before the hearing, as can be the case if they get away with it. So regardless of whether the child has recognised SEN issues or not, the family are allowed to ask for, and the admission authority must pay for, an SEN expert to attend the independent review panel. Now, I need to make it clear, and this needs to be clear in the letter, that the SEN expert is not an advocate for the family. If that's what they want, they are perfectly entitled to employ their own SEN expert, but at their own cost. So there's also therefore follows in the guidance notes about how these letters should be delivered and who they should make the appeal to, which normally would be the clerk. The hearing must be held within, as soon as the letter is received or the form is received asking for the hearing, which the guidance says should be within 15 school days, but the temporary regulations say slightly longer. They say it should be 25 school days. But clearly, if it doesn't come within those time limits, then the code says in 89 that the appeal must be rejected. If the parents didn't attend the governor's hearing, they can still request and attend the independent review hearing. And the independent review panel must take reasonable steps for a date that's suitable for all parties. And this can sometimes be very difficult because it's got to be held within 15 school days. However, the panel does have the right to adjourn. And if it's because of an SEN expert, or if it's because of the fact that parents can't make other dates, then that would be good reason to move away from the guidance. But it does say that under 92 that the independent review panel have the right to adjourn. The venue must be private and appropriate. It certainly should not be in the school. And reasonable effort should be made to circulate all parties 5 days before, school days beforehand. So who's going to be on this panel? There are 3 constituent parts. There's a lay person who chairs the hearing, a school governor of another school, but this must be somebody who has been a governor for at least 12 months over the last 5 years, and head teacher from another school, or somebody who's retired in the last 3 years. Most people would just have 3, some have 5. But most would normally just have 3 people sitting on the panel. Some people are excluded from serving on the panel. So for instance, people who are members of the local authority or the academy sponsor, head teacher of the school in question, or employees of the local authority or the academy trust or the governing body of the school in question. So basically, nobody has any direct or indirect connection or interested connection with the school. So sometimes it comes up, well, do you know somebody? Yes, if it has to be somebody you know well. If it's somebody you might occasionally see at a bus stop, you might not, for all sorts of reasons, want to be hearing their appeal, but there's no reason in law why you cannot. Sometimes this can all end up in the courts, and academy trusts or the local authority must indemnify the panel for reasonable legal expenses. And note it says the panel, not the clerk. However, it is only the panel that make decisions, although admittedly, sometimes on the advice, or I should say usually on the advice of the clerk. Where possible, governors and head teachers should be at the same level. So if it's a secondary school appeal, it should be a secondary head, but it does say where possible. So do not worry if it's from another sector. So for instance, if it's a primary head for a secondary appeal, or it's an academy head for a maintained school. The local authority, the academy trust, must consider if the chair needs legally training. I don't think this is necessary personally. I think the whole point of the person being lay should remain that they are, if they are a lay member, then they should not be necessarily legally trained. However, they probably do need to have some type of training and being a chair and being aware of the law. It says a clerk may be appointed. I would suggest it would be rather foolish not to have a clerk, but the clerk, like the panel members, all have to be trained and retrained every 2 years. So paperwork must go out at least 5 days before the hearing. And when the panel come together, so I'm moving on here pretty fast actually, character witnesses is quite important. If the parent wishes to bring a number of character witnesses, clearly you don't want to have a room which is full of people. They only come in at the time when they're going to give their character witness. And do you really need to listen to 20 people? There's no reason why the panel cannot decide we'll listen to 2 or 3. Again, this important statement about all statements need to be attributed, signed and dated. And excluded pupils are entitled to know the substance and the reasons for their exclusion. The SEN expert should not be in the room at the same time as the panel alone. So although they are the SEN expert, they are only giving advice to the panel, they're not seen to be part of the panel by being in the room with them on their own. Right. Looking at the SEN expert themselves, SEN experts must be paid for by the local authority or the academy trusts. They must have expertise or experience in SEN issues, but they're not there to assess the child. That is quite important. They're there because they are advising the panel. So panels need to be very careful about how parents or their advisors might try to use the SEN expert for their own ends. The SEN expert can be an employee of the local authority or the academy trust, but it shouldn't be somebody who's seen the child previously, and it shouldn't be somebody where there could be any doubt raised about their impartiality. They're to be a professional with first-hand experience of assessment and support of SEN issues and understand the legal requirements. The guidance suggests that educational psychologists, SENCOs, specialist SEN teachers, and behaviour support teachers make good SEN experts, and they can be retired, but they must keep up to date. Okay, so the SEN expert, looking at 83, the SEN expert is an expert witness, and it's up to the panel how they decide to use that witness. So they could allow the witness, the SEN expert, to be questioned by the family. They may wish not to. It's up to the panel. There's no advice that it has to be one way or the other. And it's up to the panel to decide how best they can advise the panel during the hearing. So who's to be there? It has to be, again, the head teacher and somebody from the governing body that reviewed the decision, preferably the chair, but it doesn't have to be. Again, with local authority representation for maintained schools, it's somebody from the local authority has the right to attend and speak, but when it comes to the academies, it's up to the parents to actually request this. And again, it's a matter whether they're allowed to speak or not is a matter down to the governors of the school. And what is interesting is there's not much about this in the guidance, but it's in the regulations in section 1.12.1. Clearly the SEN expert can be there as well. And so the panel cannot reinstate the pupil. That's not their role. They have other roles, but they cannot reinstate the pupil. But they must consider the interests and circumstances of the excluded pupil, the circumstances in which the pupil was excluded, and the interests of other pupils and people working at the school. And as with the governors, they must consider the civil standard of proof, the balance of probabilities. Be careful about witnesses. As I said earlier, a witness should only be in the room when they're needed. Because any witness that hears something being said earlier may change what they're going to say. Everybody leaves to the deliberation, only the clerk remains to help with the notes and to offer the wording advice on the decision letter. At the beginning of the hearing, section 152 says that the chair must explain the procedure and cover any eventualities under that. Let's look at the local authority. The local authority's role is quite interesting because the courts have decided that the role of any local authority in exclusion is a very sensitive one. The representations which it can make properly must be calculated to assist the committee or the panel, must bear the hallmark of clinical objectivity. So in other words, unlike many, many years ago where the local authority representative would say, I recommend that you exclude the child, or I recommend you overturn the decision. They cannot do that today. That is a big no-no. What they could do is say that looking at these circumstances, other schools, in my opinion, and from my knowledge of what they've done previously, would have permanently excluded or wouldn't have permanently excluded. So again, it's important that the local authority maintains that completely objective stance. So what should you see? Exactly the same as the governing body. Okay, so no new grounds can be submitted, but both sides can offer new evidence. And if the school does try to produce new evidence, beg pardon, if the school does try to offer new grounds, that must be excluded. So we're looking all about the decision that was made, and it's the evidence that was available that the governors made their decision. So material time is important. If the governing body were not aware at the time that the child was disabled, then clearly the governors could not take that into account. If they were not aware at the time they made their decision that the child was not in place A, but was in place B, and so therefore couldn't have done what it was alleged to have done, then material time must be taken into account. Okay, that's where the review panel then reviews what was done. So evidence that would have been available if the governors had acted reasonably, that needs to be considered. However, if evidence is presented the panel considers is unreasonable to expect the governors to be aware of, then the independent review panel must take that into account and clearly support the decision made by the governors and by the head teacher. The panel must take into account the SEN experts' views. You can't just discount them entirely. And the panel could adjourn on more than one occasion, but must consider the effect on the excluded pupil, their parents, and any victim. Victims are entitled to attend the hearing. It's up to the clerk to actually contact the victim to ask them if they want a voice either at the hearing or in written format, or maybe a video or whatever. It's not the role of the panel to reinstate the pupil. That's very, very important. The decision does not have to be unanimous. The governors exactly the same, but it is binding on the pupil, the parents and the governors. Hearings should be conducted in an unthreatening and or non-adversarial manner, and no party should be alone with the review panel. So the head teacher should not be seen to be with the review panel on their own, or the parents for that matter as well. Any adjournment on more than one occasion must be considered and looked at if there's any consequences on the pupil and the victim. If for any reason the panel goes down from 3 to 2, then it must be adjourned until all 3 constituent parts return. If one panel member cannot ever return, then the whole proceedings would have to start again from scratch. And it's important that the parents were not only given the right to speak, but also see any evidence before the meeting. Clear minutes are also clearly important as well. And incidentally, we're talking about minutes. Was the letters in sufficient detail? Because 79 says the governing body should set out the reasons for their decision in sufficient detail to enable all parties to understand how and why the decision was made. So what can the governors decide to do? What can the independent review panel decide to do? They have 3 decisions. The first is they could uphold the governor's decision. The second is they could recommend that the governing body reconsiders its decision, or C, due to flaws and using the principles of judicial review, quash the decision and direct the governors to reconsider the exclusion again. And C is the one that most parents will be looking for. So where parents are not seeking reinstatement, and that is actually now becoming more and more common, the panel need to acknowledge that, but still carry on regardless. Recording the panel's findings on the child's educational record is crucial. So any written matter must be included in the child's educational record. And the panel should not be influenced on whether the parents wish to seek reinstatement or not. So when looking at JR, judicial review, what are these areas to be looked at? And as we will discover later when we look at the Lambeth judgment, these are only 3 areas. In fact, the panel can look at any area that the parents wish them to look at. So legality, did the governors act outside the scope of their legal powers? Irrationality, did the governors rely on irrelevant points, fail to take into account all relevant points, or make a decision so unreasonable that no governors acting reasonably would have made it? We'll talk about this again when we talk about the Lambeth judgment. And procedural impropriety, was the governor's decision considered so procedurally unfair that justice was clearly not done? So when we're looking at procedural impropriety, that doesn't mean a simple breach of a minor points of procedure, but it has to be something significant like biasness, failing to notify the parent of their right to make representations. The governors made a decision without giving the parents the right to make representation, failing to give reasons for their decision, being a judge of your own cause. In other words, the head teacher excluded and also was involved in the governor's decision-making process. If the decision is decided to go for C, to quash the decision, it may order a penalty or adjustment of £4,000. Right? It's £4,000. It can't be 400, it can't be 200, it has to be £4,000. And paragraph 147 does say may order. So in other words, they could quash the decision, but not order any financial penalty. So the decision is, if you go for C, is it 0 or is it 4,000? It's nothing in between. No payments necessary where the panel recommends, so goes for B, recommends that the governors look at the decision again. And where the decision is quashed and the governors look at it again, they reinstate the child, then even if there is a £4,000 penalty, that no longer has to be paid. The guidance is quite clear that they do not expect B to be the definitive option. In fact, the guidance is quite clear unless there is actually some very serious flaws, then the governor's decision needs to be upheld. It's all done within the balance of probabilities. That's no different to any other part of this process. Rules of natural justice. Panel must work within the realms of natural justice, and these are: details of the conduct complained of must have been provided. All parties must be given an opportunity to put their case. No person who has any involvement in the matter should be involved in the decision-making process, and the proceedings must be conducted in such a way that no outsider could consider there was any unfairness or biasness on part of anybody involved. I'm now going to move on to what happens afterwards. So let's assume that the governors decided to permanently exclude. The independent review panel decided to quash the decision, and it goes back to the governors. So many things have changed since this exclusions guidance first came out when looking at this. Previously, when it went back to the governors, they didn't have to invite the parents. They now have to invite the parents. So it would suggest a second set of reviews. That's not the case. It's just looking at those areas where the panel felt that the governors had not considered A, B, and C, or there was something that was wrong. Maybe the minutes were too incorrect. Maybe the letter didn't go into such detail. Maybe the governors didn't consider A, B, and C, and they need to. It's not looking at it all again, but it can be looking at it all again, because if the decision is quashed, then clearly the governors have got to start again from scratch. Okay, so the relevant factors are the fact that when it goes to the initial review stage, it has to be held within 10 days. Once that 10 days is up, the governors must meet with the parents and they must consider the decision all over again. So who should it be on this committee? Well, it can be the full governing body, because the decision is actually for the governors to make themselves. They could appoint a new disciplinary committee, or there could be the original one, or it could be a combination of both. It's entirely up to the GP how they want to do this. But the governors do need to demonstrate how they will address the concerns, issues raised by the independent review panel, and these need to be communicated in standard English for all parties to understand. Secretary of State plays no role in the exclusion process whatsoever. A few notes here on it, on complaints, but Secretary of State is not involved. I'm not going to go through the Equalities Act or the Human Rights Act, because the notes are here for you to read, and I do not wish to prolong the verbal part of this part of the course. What I am going to do is I'm going to go straight on to the Lambeth judgment and material time as well. Material time is important because it's what happened and what would have been known at that time. So this goes back to a court case back in 2006, where the governing body of Vulture School in Suffolk, where it was concluded that they only needed to take into account information events that were known or would have reasonably known at the time. So it's all about material time. So if the parents saying, my child is disabled, and their disability was diagnosed on the 5th of November, but the hearing was on the 30th of October, then clearly at the time the governors made their decision, the decision that the child was disabled was not known. However, it could be argued that during the hearing, it was alluded to that the child did have certain disabilities, and so therefore that bit needs to be taken into account, but certainly not on the fact that the child was actually registered as disabled. Now, the Lambeth judgment, this is the only one that's gone through right the way through to the end, to a report stage. There was one more for a school in West London, but that never got through to the final stage, and so therefore there was no report ever published on that one. It was heard by Judge Collins, and he said that the facts of the case are not a particular note in themselves. He was very critical about the whole process. Particularly, he was critical that the fact that lay people were expected to make decisions on judicial review matters. The code, he said, offered 54 words of advice, whereas the average textbook run for just over 1,000 pages. However, he did make some more conclusions. He did say that any grounds for judicial review can be completed, not just the 3. There were circumstances which can lead to error of fact, which can give rise to a judicial review remedy, and much of that depends on the cases of the individual case. So again, the stress there is all done on a case-for-case basis. He said it was particularly important to consider material facts and don't be smokescreen. And that's what you will find as both governors and independent review panel members, that parents and advisors in particular will provide you with all sorts of smoke screens for you to believe their case, rather than actually pushing the smoke screen to one side and looking at actual nitty gritty. He also said that the normal rules of judicial review should apply in all instances. So that's the end of the verbal part of the course. I've given you a summary to make sure that the hearing course is far less than an hour. I would recommend that you do read the other sections and have a very good look through the guidance and the SEN Code of Practice. And good luck to all the occasions when you are hearing exclusions.